Welcome to Fortifying Futures, the podcast that unlocks the secrets of securing your legacy. Each episode is meticulously crafted to demystify the complex realm of estate planning, asset protection, and how your investments are protected. With the expertise of industry veterans and the personal stories of those who have navigated these waters successfully, Fortifying Futures offers more than just information. It provides a blueprint for action. Tune in to Fortifying Futures and transform your legal and financial journey into a strategic masterpiece. Welcome to Fortifying Futures. This is episode 1 of our podcast, and we are here to talk with Josh about one of the topics that has trended to be pretty important in our day and age, and that is second marriages and estate planning and how they come together. So, Josh, I'm glad you're here today. You and I have worked a little bit together, but you've got a specific example that you wanted to talk about.
Yeah, absolutely. Thank you for bringing me on today. I appreciate the opportunity. So our specific situation was had a parent who passed away, and then mom got remarried, and so she remarried a man that had an existing will. And wanted to make sure that his assets went to his children. Things did not get distorted between the two families. Obviously, she wants to honor her wishes. It's just kind of a different situation. So I didn't really know what the wisdom would be for that type of scenario.
Right. It happens all the time. Oklahoma, right or wrong, has a very high divorce rate. And we have a lot of remarriages. And sometimes those second marriages happen later in life when we've accumulated assets. And without proper planning, without intentionally trying to draft a plan, it can be really, really hard to hope that these wishes are honored. Because you have two sets of family, a blended family, and each spouse can have assets they're bringing in to the marriage, and maybe it's significant assets, and maybe it's not. And then they begin to accumulate assets together as a couple. So you have a his and a hers, if you will, and ours. And so you have 3 different pots of money. And how do we divide that? How are we ensuring that those assets are, going to where we want them to go? It all comes down to titling, and it all comes down to understanding who owns those assets. Now, in your scenario that you laid out, Josh, if I understand correctly, if he just had a will and she did not have a will, it really depends on who dies first.
Sure.
Right? And so we want to avoid that because we're, at that point, that particular couple is relying on the Oklahoma statutes and is relying on the fact that they were married. If they're married or unmarried, that triggers a whole different set of circumstances on how those assets are going to be passed down. And so what I would encourage them to do, if they were sitting in here today, I would encourage them to be proactive. Don't be intimidated by the estate planning process, and to reach out and to create trusts, for each one for themselves, and then one joint one together. I just did a estate plan, and the couple brought assets into the marriage. One of them had the house, right, a really nice residence. Another one had financial assets. And so they each got their own trust, one owning the house and one owning the financial assets. And then they started to accumulate more assets, so they got a joint trust together. They divided up their assets so that when the first spouse died, of the second marriage, when the first spouse died, the surviving spouse got to use the house. And the surviving spouse got to use the financial assets. And then when the second spouse died, those assets were distributed back to their original families, back to their children from their previous marriage. So by being intentional with that, by reaching out and designing a plan, it's very simple. It sounds intimidating, like a lot of estate planning, but by being intentional, we created a plan for them that worked really, really well. And in this particular case, it's likely that the homeowner, the person who brought the home into the second marriage, they will pass away first. But their concern was that their new spouse be able to live in that house. That was very easy to draft. We were able to get that together and make sure that their wishes were carried out. But I'll tell you, Josh, one of the gifts that they are giving their kids is a clear plan. Because without that, then it seems to me that the siblings or the children and even the stepchildren can begin to argue and fight and talk about what should have happened or talk about what they wanted to happen. And all you're doing now, all that couple's really doing is setting up their families to fight. And that ultimately will start to tear at the fabric of a family all over assets that so easily could have been avoided.
Sure. That makes sense. And one of the things is both sets of kids were on the same page. We wanted to make sure his assets went to his children, her assets go to us.
Right.
And so to make sure that there's that clear delineation with that. And so there was just some confusion of what do we do? How do we go about it? What's the legal process to make sure to guarantee, because there's peace of mind for everybody that we're never going to have a fight.
Right, and that's really what you want. And sometimes, if you're not intentional about that, you don't take a proactive step, and you don't communicate to the kids, people can get ugly when it comes to stuff, and they get pretty fired up, and they get pretty emotional about that thing. Especially if it's a second marriage in there, and the other side, the children on the other side aren't the good guys, and my side's the good guys, and your side isn't. Then by not being clear, not being intentional, it just sets the groundwork for arguments. I had another client once who had substantial assets, and then they started a business together in their second marriage. And we had to be very clear how that business was divided. That included loans back and forth and papering that up. But one of the things that this particular family did was they invited their adult children into the planning process. So they sat down at the table with us, and they understood why we did it and why there was a promissory note. They understood why that we did the LLC this way and how these assets are divided. But the kids were involved from the start, the adult children. And I thought that was a really cool way of making sure everybody knew what to expect, and not only what the decision was, but why we made that decision. And I think we'll see how it plays out, but I think right now the family seems to be getting along pretty well.
That's great.
So it was good. So tell me, in this particular situation, tell me about some of the assets that each people have. Sometimes there's a disparity in the wealth side. Sometimes there's not.
There is a disparity. I mean, one side was house, assets, insurance policies. Other side was definitely assets, oil and gas, minerals, and just a few other smaller. But it was definitely lopsided in the value of one versus the other.
And that's, Josh, by the way, that's not so bad. I had another client who one of them brought in a lot of assets, and the other brought in quite the opposite. They brought in debt. They brought in debt to the marriage. So how do we handle that, right? There was a mortgage, of course, and that's probably fine because it's secured by the house, but somebody brought in a lot of credit card debt. And so estate planning allowed them to make that right from a financial standpoint when they both passed, because they loved each other. Their second marriage, they wanted to be successful, and so estate planning allowed them to be intentional in paying off the existing debt that was out there, but not to the detriment of their own kids. So I think your situation is.
So you're saying it's not a good thing to bring debt into a marriage? Would you advise against that as an estate planning attorney?
I would advise to have a plan for that. Love conquers all, but it just doesn't pay off debt on its own. So I would sometimes if we don't understand it or we're intimidated by it, we just ignore it and hope that it works out. And during that second marriage, it probably will. The marriage will work out and everybody's fine. It's their ramifications, the untold, the unexamined, the unsolved problem that invariably shows back up and just rips at the fabric of a family. And sometimes when it's at its most vulnerable, when two people have passed or maybe one person's passed in a second marriage, that's when these arguments can start, and that's what we really want to avoid.
Sure. That makes sense.
Yeah. Thank you for listening to Fortifying Futures. This is the podcast that unlocks all the secrets and all the mysteries surrounding estate planning. And we want to make sure that we're answering all your questions. So keep them coming. Let us know what's on your mind. Let us know what concerns you may have or anything that we didn't get to. We'll do our best to get to those on the next podcast. And you can reach out to us via email at clientintake@bml.law. Again, that email address is clientintake@bml.law. And you can always call us at 405-701-5355. Again, that's 405-701-5355. 888-882-5355 and check out our website at bml.law. There's a lot of great information out there, a lot of great resources and tools, and our goal at Balmore Slow is to provide thoughtful law for today and in the future. Thank you.